My name is Sheila. Welcome to my channel. In this video, we're going to be talking about Rocket Lawyer's non-disclosure agreement, also sometimes referred to as a confidentiality agreement. I'm going to be reviewing that document with you, letting you know my thoughts on it, some things to watch out for, some red flags, and maybe when you should use this document. So let's jump right into it. If you've never been to one of my many channels before, then welcome. This is the channel that is focusing primarily on legal topics. And for those of you who I guess are just joining me for the first time, yes, I do have on workout attire because, as you will see on my other channel, I mix all of this stuff up together. But that's not what you came here for. Let's jump right into this non-disclosure agreement. Why do we want to use a non-disclosure agreement? Well, a lot of times we're trying to keep something secret, right? It might be, if you're KFC, your special recipe that you use on your chicken. But if you're just a regular business owner, you're concerned about this other party maybe walking away with some of the newest and latest and brightest ideas that you're going to be putting into place in your company, and taking it and running off with it and starting their own company with it. Or hey, maybe they're using your customer list, your clients that you have that you rely on. You need to keep all of this stuff secret. You need to make sure that they aren't using your confidential information for their benefit and not for anybody else's benefit either. You want it to stay secret. So let's jump right into the document and take a look at it and see what it says, whether or not this is anything you really need to use. So first of all, the document is actually fairly short. So it's not anything that's going to make you want to run and hide. It is pretty simple, pretty basic to understand. You know, a lot of times these documents will have a lot of legalese, a lot of words that you have no idea what the meaning of these things are. But this is actually a fairly short document, and you can pretty much understand it. There might be a few things that you need to look up. So let's start here at the very beginning, this very first opening line that says this non-disclosure agreement is made effective by and between. So here's the thing that I always tell my clients, and it does not matter what kind of agreement it is. The other party who is signing the document, make sure that they have authority to do so. So if it is with another company, an LLC or a corporation, you actually want to look them up in your state's Secretary of State's office to make sure that, number one, they are legitimately registered, still in good standing, and that they have not been administratively dissolved. The other thing you can kind of check on sometimes too is who's actually running this company, and it'll give you an idea whether or not the person who's signing is the person who has the authority to sign. All right, let's jump right into confidentiality. Here they've got a full paragraph on what that means. And again, so it gives you an idea here of some of the things that could be considered confidential information. And here's the thing that you really want to make sure is in your agreement. This part that says, regardless of whether specifically identified as confidential or proprietary, it shall include. So that is stating, even if you don't put confidential on it, if it is something that's supposed to be confidential, that is the case. It doesn't have to be stamped with the words confidential on it. The thing I do like to tell people though is try to do that whenever possible. It is helpful. It does serve as a reminder to people that this is not something that should be released. And you know, most of the time, people know when they shouldn't be telling someone else. But the last sentence is really key too. The nature of the information and the manner of disclosure are such that a reasonable person would understand it to be confidential. So there you go. That's sort of your standard. If a reasonable person would sort of say, yeah, dude, you should have known that that was confidential, right? No, you're probably not going to be off the hook if you're the person letting this go. In case of the business owner who actually has the material, then this is a good thing because it sets sort of this objective standard, like what would reasonable people think? 1A down there, you see they've got what it doesn't include. So yeah, if it's already public information, if it's already something that they knew, if you've specifically agreed that it's not going to be confidential, hey, it's not going to be confidential. All right, so 2 gets into that protection of confidential information, talks about no disclosure, no copying or modifying, authorized use, and application to employees. So yeah, so if you're having to share it with this other party, you also want to make sure that they aren't giving it to any and everyone, that it's limited to the work that they have to do with you. You may also, if you're the person who holds the confidential information, you may be able to get an injunction to stop the other person from releasing that information. So that's what number 3 is about. Okay, number 4 is one of the ones that I want you to take a look at, because this is one of the ones I was really sort of concerned about. This non-circumvention phrase, or provision, I guess is what I should term it. It really reads more like a non-compete clause, okay? So it says for a period of 5 years, and hey, if you want to retool this, you could throw your own time period in there. The recipient will not attempt to do business with or otherwise solicit any business contacts found or otherwise referred by owner to recipient for the purpose of circumventing, the result of which shall be to prevent the owner from realizing a profit. Okay, so it really reads more like a non-compete. Like you can't take my information and then go out again and compete against me in the same business area that I have already been operating, and you're taking my resources and material and information to use that against me. So this is really what this is about. In a general sense, if you just had a non-compete agreement, it would have way more information in there. So some of the things that a court will look at to determine whether or not your non-compete is valid, they want people to be able to move about, to be mobile, to be able to get jobs and start businesses wherever they need to be able to do that. If a person has skills and talents, they've gone to school, they've gotten all of this knowledge, then they should be able to use that. The government sort of frowns upon non-competes that are very broad and very general. And so if they don't have a specific time frame, if they aren't limited to specific skills and talents or knowledge, and if they have this sort of broad geography to them, then a government's going to say, well, wait, didn't they go to school for that? Or didn't they learn that on the job? And you're telling them now they can't go anywhere in the world to do this. So I'd be really careful about this non-circumvention provision in here, because it does sound like a non-compete, and yet it's not as specific as courts would like to see. So if you're going to tweak this, then I would suggest that you be very specific about the area that this person is going to function in. Now, granted, we're all in this sort of digital space now, and so everybody competes against everybody all across the world. But in general, you really want to be able to say, this is the market in which my business, in which I operate, and it's just in the Southeast US. So I'm going to say Georgia, North Carolina, South Carolina. They cannot compete with me there for the next 2 years if it has to be something that we work together on, or that they had knowledge about my business. They had knowledge of my business because of it. Yeah. The next one is not so hard. Return of confidential information. The only thing I really want to stress here, though, is this part about assuming that everything is hard copy, right? That you can actually just give the documents back. You also want to make sure that if they have it in electronic form, that there's a provision that covers its destruction, right? Or its removal. This just specifically talks about returning it. So it says, upon the written request of the owner, the recipient shall return to the owner all written materials containing the confidential information. The recipient shall also deliver to the owner written statements certifying that they have been returned. Well, that's great for written materials, but what about digital materials, emails, things that might be stored on someone's flash drive? That's totally left out of this. And so you really want to take a look at this and say, there are circumstances where I have emailed confidential information to someone. I need to make sure that destruction is actually included in this. Then we have relationship of the parties, no warranty about the information that's being shared. The person just has a limited license to use it. Each party is going to indemnify the other. So if I do something wrong and you do something wrong, hey, I'm covering me, you're covering you. We've got some general provisions here that do talk about the state, and you do want to make sure that, if you're the person writing this, that you're following the laws in your state regardless of what this other party wants. That's pretty much it. That pretty much wraps it up. So yeah, it's definitely a document that you can use. I just think that these areas are ones that need, I just think that there are a few areas that you definitely want to take a look at. One is the opening paragraph where you're talking about who the parties are. You also want to be careful about this non-circumvention piece. And then you also want to be careful around return of property. So just keep those things in mind when you're using any sort of form that you can download from the internet, or if you're using Rocket Lawyer Services or something like LegalZoom or Law Depot. There are tons out there. You just have to go through them and figure out what works best for you. So go ahead and subscribe to the channel, like the video. I'm going to be sharing a lot more videos in 2021. I'm trying to get things up to speed, hoping to kick off a whole lot more soon. And stay tuned. If you want to check out just my regular vlogs where I'm living my life as an attorney, talking to you about what that looks like, trying to be healthy and fit at the same time and have a great lifestyle, then also check out my other YouTube channel, Shelia Huggins Now. All right. Mwah.